Do you have a will? Great. But if that's all you have, your family could still end up in court fighting over the right to help you. Let me explain why your will isn't enough and what documents you're probably missing. I hear this all the time. I have a will, so I'm all set. And I wish that were true. I really do. But here's the reality. Your will only works when you're gone. It doesn't help if you're in an accident and unconscious for weeks. It doesn't help if you have a stroke and can't communicate. It doesn't help if you develop dementia. Your will handles what happens after you die. But what about all the times you might need help while you're still alive? Today, we're talking about 5 essential legal documents that work alongside your will. These protect you and your family during some of life's most challenging moments. I'm Charlie, and welcome back to Family Life Fix, where we talk about end-of-life planning in a practical, judgment-free way. If you're new here, this channel is about helping you protect your family through thoughtful planning. We tackle the difficult conversations and decisions so your loved ones don't have to figure everything out during a crisis. I've been fortunate to see what comprehensive planning looks like, and I've also seen what happens when families only have part of the puzzle in place. The difference can be devastating. So let's walk through these 5 documents together. Think of them as your safety net for the unexpected moments in life. Here's something that might surprise you. About 80% of Americans understand that estate planning should be a part of their financial planning, but many people think having a will means they're fully prepared. The truth is, your will only takes effect after you pass away. It's a critical document, but it leaves a huge gap in your planning. What happens if you're in a serious accident and can't make decisions for yourself? What if you need someone to pay your bills while you're recovering from surgery? What if you can't communicate your medical wishes during a health crisis? Your will doesn't address any of these situations, and without the right documents in place, your family could face weeks or months of legal battles just to help you. That's why these 5 additional documents are important. They fill the gaps your will can't cover. First up, durable power of attorney for finances. This document lets someone you trust manage your financial affairs if you become unable to do so yourself. Here's why this matters. Without this document, if you become incapacitated, your family has to go to court to get legal authority to handle your finances. We're talking about a lengthy process that can take months and cost thousands of dollars. Meanwhile, your bills still need to be paid. Your mortgage is due. Your credit cards need attention. Without this power of attorney, your family has to watch helplessly while your financial life unravels. The durable part means it stays in effect even if you become mentally incapacitated. It's your way of saying, if I can't handle my finances, here's who I trust to do it for me. It's one document that can help save your family enormous stress and expense during an already difficult time. Document number 2, Healthcare Power of Attorney, also called a Healthcare Proxy or Advanced Healthcare Directive. The specific name varies by state, but the process is the same. This document lets someone make medical decisions on your behalf when you can't make them yourself. And here's something many people don't realize. In most states, your spouse, your parents, even your adult children don't automatically have legal authority to make medical decisions for you, not without this document. Hospitals may not be able to share information with your family or accept their input on your care. In the worst cases, decisions could fall to a court-appointed guardian who doesn't know you at all. The age requirement to be named as a healthcare proxy is 18 in most states, though Alabama and Nebraska require you to be 19. This document ensures that someone who knows you, loves you, and understands your values is the one making medical decisions if you can't. Document number 3, HIPAA authorization form. HIPAA stands for the Health Insurance Probability and Accountability Act, and it's the law that protects your medical privacy. This form gives specific people permission to access your medical information and speak with your healthcare providers. Without it, your healthcare team legally cannot share information about your condition with your family, even if you're unconscious or unable to communicate. Here's what makes this document particularly useful. It takes effect immediately when you sign it. You don't have to wait until there's an emergency. That means your spouse can call to refill your prescription on your behalf. Your adult children can attend a doctor's appointment with you and ask questions. Your designated person can coordinate your care. And here's the good news. This is one of the easiest legal documents to create. In most cases, you don't need a witness or a notary. Just sign it and you're done. It's a simple step to ensure your family can help you when you need it most. Document number 4, beneficiary designations, particularly for retirement accounts. This is important. Your IRA, 401k, and pension accounts don't pass according to your will. They pass according to the beneficiary forms you filled out when you opened those accounts. Many people fill out those forms years ago and never thought about them again. But those forms control where potentially hundreds of thousands of dollars will go. If you don't have the current beneficiary designations on file, the money typically goes to your spouse first, then your estate. But policies vary by institution, and sending money through your estate means probate, which means delays and additional costs. For 401k accounts, if you're married and want to name someone other than your spouse as beneficiary, you'll need your spouse's written consent. That's federal law. And here's a recent change. The Secure Act now requires most non-spouse beneficiaries to withdraw inherited retirement funds within 10 years, which can have a significant tax implications. The bottom line, review your beneficiary designations regularly, especially after major life changes like marriage, divorce, or the birth of a child. Document number 5, guardianship nomination or standby guardianship forms. This is particularly important if you have minor children. Your will names guardians for your children if you pass away. But what happens if you're temporarily unable to care for them? What if you are seriously ill and hospitalized for months? What if work takes you overseas unexpectedly? Your will doesn't help in those situations because you're still alive. That's where standby guardianship comes in. This document gives someone legal authority to care for your children when you're temporarily unable to do so. The key difference from your will is that you don't lose your parental rights. You're just designating someone to step in during a specific period. Now, here's where it gets tricky. The rules vary significantly by state. In Washington, D.C., the designation is only valid for 90 days unless filed with a court. In Maryland, it's good for 180 days. In New York, you need 2 witnesses to sign the document. If you have children, it's worth understanding your state's specific requirements for this document. This brings me to an important point. State laws vary significantly when it comes to these documents. What's legally valid in California may not work in Florida. What's required in Texas may be different than what's needed in Oregon. Some states have registries where you can store advance directives for quick access by medical professionals. Some states require notarization for certain documents. Age requirements, witness requirements, and the validity periods can all differ. The good news is that in most cases, if you move to a new state, your healthcare documents will still be honored. But most cases isn't all cases. So it's worth reviewing your documents when you relocate. And here's something that often gets overlooked. These documents need to be updated regularly. Your beneficiary designations should be reviewed every few years or after major life changes. Your powers of attorney should reflect your current relationship and wishes. Many people create these documents once and forget about them, but life changes, relationships evolve, and your documents should evolve with them. Look, I know it's a lot to take in. 5 different documents, each with its own rules and requirements. It can feel overwhelming. But here's what I want you to remember. These documents are gifts you give your family. Your way of saying, if something happens to me, here's how you can help. Here's what I want. Here's who I trust. Without them, your family could face months of legal battles, thousands of dollars in court costs, and the heartbreak of not being able to help you when you need it the most. Your will is important, absolutely, but it's only one part of comprehensive planning. These 5 documents work together to protect you and your family through whatever life brings. If you're thinking, Charlie, I don't even know which of these documents I have, much less if they're up to date, I've created some tools for you. I have a free quiz that helps you identify exactly where your planning gaps are. And if you want a complete system that walks you through creating and organizing all these documents, I have something really special launching on November 28th, the End-Of-Life Planner. Head over to FamilyLifeFix.com to take the quiz and join the waitlist. You'll be the first to know when the planner drops. Link is in the description below. Planning isn't about preparing for the worst. It's about protecting the people you love, and that protection starts with having the right documents in place. I'm Charlie, and I'll see you in the next video where we'll continue helping you plan better for the people you love.